Next, trademarks. These are also issued by the USPTO. Trademarks are legal instruments represented as words, symbols, phrases, designs, or some combination thereof. They identify and distinguish the source of goods or services of one party from those of another. This protection lasts 10 years and can be renewed indefinitely. A common misconception is that a trademark means you own a particular word, phrase, or symbol. That's not exactly the case. Rather, it means you have the right to use that word, phrase, symbol, or design in a specific domain that relates to the specific goods or services you are selling. For example, let's say you use a logo as a trademark for your small woodworking business to identify your goods and services from others in the woodworking field. That doesn't mean you can stop others from using a similar logo in a non woodworking related field. Take Delta. Everyone is aware of Delta Airlines, but Delta is also a company that sells faucets and plumbing fixtures. There's no real risk of consumers misunderstanding the Delta brand because these are such different domains, so both companies are allowed to have trademarks around the name Delta. The same goes for Dove, a very common soap and body care brand and also a popular chocolate line. Since these are such different markets, they are both allowed to trademark around the word Dove. Let's move on to copyright. This category of protection is issued by the U.S. Copyright Office in the Library of Congress. A copyright is a legal instrument giving the creator of an original work exclusive rights to it, usually for a limited time. Generally, it's the right to copy, but it also gives you the right to be credited for the work and to determine who else can adapt, perform, or financially benefit from it. One unusual thing about copyright is that protection begins automatically the moment an original work is created and fixed in a tangible medium of expression. You do not need to publish the work or register it for the protection to start. However, you can register it if you would like to, and the need to do so will vary case by case. Regarding the term, it's a little more convoluted than the timelines for patents or trademarks. The length of copyright depends on several factors, including whether it is published and the first date of publication. As a general rule, works created after January 1st, 1978 last for the lifetime of the author, plus an additional 70 years. There are other caveats, so I encourage you to read more on the Library of Congress website if you'd like to go deeper. One of the main reasons a STEM innovator may be thinking about copyright is in the case of software or computer code. Some elements of software may be patentable, but generally speaking, code is considered written word, the same as a book or song lyrics. So, registering code as a formal copyright may be one option for IP protection. This is a case where it's really important to talk to your tech transfer office to ensure you're pursuing the best plan for your IP. Publishing your code in order to file a formal copyright would mean sharing the secret sauce of your app or program. There is a business risk that someone could reverse engineer a very similar program without technically infringing on your rights. So, this is a complex decision, and you'd be helped greatly by talking with your TTO. That leads us to our next type of IP: trade secrets. This is the legal term for confidential business or technical information. It basically means you are going to keep it secret and known only to a limited group of people. To qualify as a trade secret, the information must be commercially valuable because it is secret, known only to a limited group of persons, and subject to reasonable steps taken to keep it secret. The unauthorized acquisition, use, or disclosure of such secret information in a manner contrary to honest commercial practices is regarded as an unfair practice and a violation of trade secret protection. Examples of technical information that might be kept as a trade secret include pharmaceutical test data, designs or drawings of computer programs, proprietary algorithms and code, or manufacturing processes. On the business side, things people choose to keep as trade secrets include customer and vendor lists, advertising strategies, or some combination of these business elements. When we think about well known trade secrets, the Coca Cola formula comes to mind. Nobody knows exactly what's in the Coke recipe. That's by design, it's kept under lock and key. The same goes for KFC, the chicken restaurant. Their blend of herbs and spices is also kept as a trade secret. That's how they have chosen to protect that intellectual property rather than publishing it where people could create some form of close imitation. So it's a great strategy. And it's important to talk to your tech transfer office about trade secrets along with the other forms of IP.